What are some tips that you would give represented fathers in terms of working with their attorney to build a strategy, and then also the pro se dads that are trying to do it on their own?
So, well, as far as represented people, it can be hard to let go of control to somebody, and I think that's where communication and a good rapport with your attorney comes into play, where you can talk to your attorney and say, hey, these are the goals I'm trying to achieve. How do we get there? But, if your attorney says, well, this is the case law and this is what, then, in some respects, you do have to defer to your attorney because that's why you hired them, is for their education and expertise. I think something too, I'm starting to see sort of here in Colorado is, you do get attorneys sometimes that dabble into family law. In my opinion, family law isn't something you dabble with. You either do it primarily or you don't, because, things are changing. There are always laws that affect things, at least here in Colorado. So you need to know what you're talking about and need to know the most current case law. As far as pro se people, obviously it's a little more difficult, but again, like I said before, recognize that you are going to be held to the standard of an attorney. So you do need to make sure that you know the rules. You need to make sure that you know that there are certain deadlines for filing things, that there are certain, for instance, in Colorado, we have to confer. And that means before you file pretty much anything, you have to reach out to the other side and say, hey, I'm going to file this motion. What's your position? And you have to put that in your motion, because that's something I see pro se people get hung up on all the time. And judges don't appreciate that, because there's a reason for that, is to see if there's something you can work out instead of just inundating the court, which is why we're setting in January and February right now. So know the rules. That's a big thing. Know the case law, do your research. And, I think too, always bounce ideas off of people and see how it sounds, people that you trust. Because like I said, judges are human. So a lot of times, I'll bounce stuff off, maybe my husband, like, hey, if, in this theoretical situation, how does this argument sound? Does this make sense? And he can tell me from a layperson's standpoint, because I feel like if another layperson understands what you're saying and it's clear, then a judge is going to understand it as well. So, and practice your arguments too. Lawyers still, I still practice, in my head, write stuff down, bullet points. This is what I want to argue to see how it sounds. And that's another thing too. I see pro se people come in with written questions and they're just beholden to those. The case better than anybody. Come in with bullet points, have some flexibility, but remain calm, and get the facts across, because that's what the judge is looking at, facts and law.
Yeah, preparation piece. I'm always a big fan of having that one sheeter that it's, okay, this is the purpose of the hearing. This is what we're going to argue. Here's the strengths. Here's the weaknesses. Here's their strengths. Here's their weaknesses. They're probably going to argue this. We may need to call this audible. It's right there, all on one page.
Exactly. And also, the big thing, know things like hearsay. It gets thrown around on TV all the time. Doesn't mean what a lot of people think it means. I think some attorneys, in all honesty, some attorneys don't understand what hearsay is. But so no, if you come in with this stack of exhibits that, you might not necessarily have to or be able to just hand them to the judge, you're going to be expected to lay foundations and make sure that they comply with the rules of evidence, at least here in Colorado. Also have copies for everybody, copies for the judge, copy for the other attorney. Share things ahead of time. I see a lot of pro se people come in with, a stack of documents that I haven't seen. And the first thing, of course, as an attorney, I'm going to do is object, because that hasn't been shared with me. Some judges will say, okay, we'll take a brief recess, share that with her. And some judges will say, you know what, you didn't share it, so you don't get to use it. And that again comes down to knowing the rules, which again, even, if you can't maybe afford an attorney, there are things you can hire an attorney typically at a lower rate to do what we call, in Colorado, a Rule 11, where we might draft the pleadings for you. We'll help you with, strategy and things like that, but we don't actually go to court with you, but we'll tee you up for court. And so that's something you can talk to an attorney about doing at a lower rate.
Yeah, and I think the big thing with pro se litigants, you have to realize all the rules of the courts are designed that nothing's a surprise when you step in front of the judge to either party.
Exactly.
So being afraid of reaching out to opposing counsel and saying, what's your position on this? Or sending them the documents ahead of time. Your rules of civil procedure in each state, and depending on the type of hearing, will lay out exactly how many days you're supposed to get opposing party those documents. Everything's designed to not be a surprise.
Exactly.
To be honest, if it's gonna be pro se litigant versus an attorney, and we're just gonna make a bunch of surprises, it's gonna be whatever goes. The attorney's probably gonna win, just because a lot of family law stuff works on pattern. It's gonna go A or B, and we know that, and you have no idea.